All right, cupcakes, I told you I'd be back, and like a bad nickel, like I said before, I am. Today we're doing intro, and this week, I'm sorry, we're doing intro. It's week 2 of intro 3, and this week happens to be medical law and ethics, all right? Now, let me explain to you one thing. The law is right here, ethics are way up here. And you all are entering a profession of healthcare providers. And this profession has been around for many, 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 many years. And it has developed a standard of ethics. You are going to have to rise like the cream to the top and come up to those ethics. The profession is not going to come down to anybody, all right? You wanted to be treated with respect, you've got to treat others and act with respect. Now, let me tell you the difference between law and ethics. It's about 10:30, 11 o'clock at night, and you're leaving a friend's house, and not in too great of a neighborhood. You come to a four-way stop, and you notice there's nobody else coming in either direction. You kind of look both ways and then you just go, right? Where's the first place you're going to look when you're driving off? If you're honest, you're going to say you look in your rearview mirror, because that is ethics. Ethics is like your conscience, all right? You know, I'm sure that the officer, if they stopped you, would have no problem with letting you go, seeing that you're, a single female in a car driving at night in a neighborhood that they were unfamiliar with. So, polite and would get you out of it. So that's ethics. Ethics is like your conscience, all right? Okay, now we're going to get started with the definitions, and there are several, as you can see. The first one is power of attorney. And that is a legal instrument, meaning it's a document, not an instrument like, a guitar. It's a legal instrument authorizing a person to act as an agent of the grantor, of the person that's want them to be the power of attorney. It allows one person to act on behalf of another. There's different types of power of attorney. When my mother-in-law was living with us, there was medical power of attorney. There's financial power of attorney. There's all kinds of powers of attorney. And so, you have to appoint somebody that would speak on your behalf. Ordinances, these are local governments create and enact. There's an ordinance that says you can't park on the neutral ground. Well, when the weather gets bad and it rains and it floods, they disavow that ordinance maybe for 24 hours, and they will allow you to park on the neutral ground to avoid your car being flooded. All right, that's an ordinance, and they're set by local governments. A misdemeanor is a minor crime. It's a misdemeanor, okay? Felony, on the other hand, is a major crime. Rape, murder, burglary, that is a felony. Then we get into kind of like the blue collar kind of stuff. Malfeasance. Mal in Latin and Spanish means bad, all right? Malfeasance is the performance of an act that is wholly or completely wrong. You shouldn't have done it, but you did it anyway, all right? And if I have time later on, I'll give you an example with my youngest daughter's a nurse also, and I'll tell you what she worked with. So that is malfeasance. Misfeasance is the improper performance of a lawful act. In other words, it's legal what you did, you just did it improperly, all right? That's misfeasance. Nonfeasance is the failure to perform an act that should have been performed. When every patient comes in, you take their vitals, temp, pulse, respiration, all right? It's boring, it's mundane, you do it all the time. You go in one day and say, nah, they won't notice if I don't do it. That's non-feasance. You didn't do something you were supposed to do. Fee splitting, this is bad, 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 bad. It's an unethical practice, okay, which means it's above the law, where doctors are paid for referring patients. You go to your general dentist, and they discover you're going to need something where you need an oral surgeon. Well, this guy has one that he always recommends. Now, there's nothing wrong with that, except if they split the fee. Okay, that's not kosher or legal. Battery, and I'm not talking about the one that goes in your car. Battery is the non consensual touching. If the doctor fails to get a consent before treating a patient, if you walk into a patient's room without announcing yourself or asking the patient's name, don't ask them, but I'm Miss Orlando and your name is? Okay, don't tell them their name, I mean. When you walk in and start doing vital signs on a patient without notifying them, that's battery. It's the unlawful touching. You didn't get permission. In other words, I'm going to say, I'm going to take your vital signs, your temperature, pulse, and respiration. And 99.99% of people go, oh, okay. And they'll stick their arm out or something, all right? That is what we're talking about as far as no battery. Deposition. A deposition is a type of testimony like somebody would give in court, but it's not limited to the parties of the lawsuit, okay? And in other words, they can get depositions from people that witnessed the accident. They can get depositions from doctors. But I need you to know that this D, the word starts with a D, is not one of the 4 Ds of negligence, okay? All right, contributory negligence. Now, this is not a good one at all. This is when the patient contributes to their own condition. And I hate to say it, but men are the worst for it. You finally convince them they need to go to the doctor, all right? And they go to the doctor, and the doctor says, you have hypertension or high blood pressure. Here's a prescription for the medicine. On the way home, they're going to get the prescription filled because they know if they come home with the prescription not filled, you're going to complain and do a lot of other stuff. Starts with a B, but I can't say the word. So they get the prescription filled, and the first day or two, they're very good about taking it. After that, the bottle kind of disappears. You don't see it anymore. They don't take their blood pressure medicine. They have a massive hemorrhage and a massive stroke, a massive cerebrovascular accident, a stroke. They're in the hospital dying, and the family is up to the doctor. Well, you gave him medicine. He was taking the medicine. Well, bring the bottle and let me see it. I gave him this bottle 28 days ago. Should be 28 pills missing. There's only 2. He was not taking his medicine. Or when people fail to keep appointments, all right? And I'm not talking just for a general checkup. I'm talking if, let's say the doctor put you on new blood pressure medicine. They want you back in a few weeks to see if there's any side effects or if it's working. You don't show up, then you wonder why the medicine's not working, all right? Okay, dereliction. This is failure to perform a duty. It's almost like the one nonfeasance, all right? Assault. You always hear assault and battery usually together. This is the intentional threat to harm another. It is also the willful and unlawful use of force or violence on a person. That's assault. It's a lot worse than battery, but I wouldn't want to be involved in either one. Slander is oral defamation. You have to watch this between your nose and your chin. This can get you in a lot of trouble. So don't go around bashing or bad-mouthing your previous employer. I'm going to tell you how not to do it. I used to teach and do externship. I had 2 friends. They didn't live near each other, but they were friends. I mean, they'd been friends forever. Went to school together, went to Eastern together. And I set them up at 2 different extern sites. One was in Kenner, one was in, Metairie. And the first day, they went there and they were, well, at lunchtime, they call you, how do you like your site? What do you get to do? What about this? What about that? One girl loved her site. The doctor was great, let her examine things and do things. The other one said, I'm working for a man doctor, not a woman doctor like you are. And this guy is nuts. His office is like a pigsty. He doesn't care about the patients. He doesn't wash his hands. He doesn't do this and that and this and that. They hang up the phone. A little while later on, the girl that has the female doctor she's working for, she says, boy, am I glad I got you and I didn't get to work with that guy that my friend so-and-so's working with. And she said, well, why? What's the matter? Oh, he doesn't do this. He doesn't do that. He's terrible. He's sloppy. He drops instruments, picks them up, and uses them again. He's just terrible. She said, what's this guy's name? And when she told him the name, it was her husband. Now, they didn't have the same last name because when she graduated from school, she was not married. So she used the same her maiden name on her license. They were husband and wife. How long do you think they lasted at those sites? I got a call within an hour. They were both kicked off, all right? Yeah, so watch that because it may seem like, I know there's no phone books anymore, but the phone book seems real thin with dentists and oral surgeons and all. You let something happen, it's going to go from Kendra to New Orleans East in less than an hour. People will know about it, all right? All right, guardian ad litem, number 15. That is a legal representative of a minor. I don't know if you all old enough to remember Gary Coleman. He played on like The Facts of Life or something, but it wasn't that. He was the little bitty black guy. He was a great actor. Well, he was so young, small, he could play a child, and he was in his 20s, and he was playing like a 6-year-old. Well, his parents were his managers and whatever, all right? They cleaned this guy out. He's working his butt off, doesn't have a penny to show for it. Didn't know it was going on because it's his parents after all. Well, eventually he sued them, went to court and sued them, and he was still a minor. I don't think he was in his 20s yet. He dropped them as managers, and he actually sued them so he could have somebody else be his legal guardian, not even his parents. All right, public domain. This is certain types of news. Births, deaths. These are things that are made public, all right? You can call the Department of Birth Certificates and find out anything on anybody. You can do the same with death certificates. Okay, negligence must be proven. If you accuse somebody of negligence, it must be proven that they were negligent. If not, they're going to sue you. Living will. That is a document that expresses the wishes of a patient with a terminal illness or accident where they can't express their own wishes. So, power of attorney is one thing, that you're alive and the other person is there just in case. But a living will states that, and when you check into a hospital, they always ask, do you have a living will? My daddy had a living will, and he was almost completely dead when I found him in the bedroom. I don't know why I called an ambulance and brought him to the hospital. It was stupid. But anyway, they kept asking me. They wanted to do this and do that and do this. My daddy was cold. He was blue. But he was breathing. And of course, I said, and it was so difficult for me to say, no, don't do it. He has a living will. The daughter in me wanted to say, hey, plug him up to everything you got. But I knew that wasn't what he wanted. And in his state, he would have been a vegetable if he would have survived anyway. All right? Okay, duty is an obligation that people have or they perceive themselves to have. It's your duty to make sure that the door is locked at the office when you leave every afternoon. It's your duty to make sure the answering machine's turned on so we can go to lunch, okay? Manifestation. This is something that is easily understood or recognized by your mind. It's a manifestation. Oh, I understand. I get it now. Yeah, oh, okay, I remember. Yes, I get it. Now, what I have here is just something FYI. We live in a very litigious society. That means sue happy, sue crazy. Look at the number of commercials on TV for attorneys. It makes you want to throw up. There's one behind the other, behind the other. I remember days where the attorneys and doctors could not advertise. Doctors, I don't think still can, but attorneys, once they said they could, that's all it took, all right? Negligence, like I said, must be proven. Now, general damages, if you sue somebody, general damages include compensation for pain and suffering, all right? Sometimes they say, you can't put a dollar amount on it, I'm hurting. So what gets me is, and I know this, it's still on the subject, but you'll see these commercials for one particular guy. One call, that's all. I'm not going to say his name. But these people are in such bad accidents. They have to have shoulder surgery, back surgery, whatever. But yet they can sit on the sofa and smile, feeling great, saying, he got me $400,000. Let me tell you something. I was in an accident. I had to have back surgery. That was when I was 27. I still don't smile to this day because of the pain. I don't know what kind of money and what kind of magic this person works on their actual injury, but it money doesn't make you that happy. I'm sorry, it doesn't. All right, medical liabilities. We're on the second page. Medical liabilities stem from a breach of trust on the doctor's part. Okay, medical liability, you can be responsible. Or a breach of trust on the patient's part. Or it can be a misunderstanding between the patient and the doctor. This is where a medical liability, in other words, you don't have a good relationship, all right? And doctors nowadays, I don't think sometimes they really listen to the patient. They're more interested in typing what you're saying rather than actually looking at a patient eye to eye. I would prefer that, all right? So, you got to have a good relationship with the doctor, and you all have to understand each other, or somebody's going to end up being sued. Okay, I sat on a board one time where a medical assistant and the doctor were being sued. The girl had given the same patient the flu shot for years. And this one time she was not paying attention. She gave her the shot in the arm and she used a needle that was too short. Well, the woman developed what's called tetany. Not tetanus, but tetany, which is a state of constant muscle contraction. And it wouldn't go away. And it's painful. And she sued the doctor. And when you sue the doctor, you're going to sue the medical assistant. You're going to sue the doctor. The MA doesn't have the money, the doctor does. And she won, unfortunately. All right, civil laws are called tort cases. And what that means is no law was intentionally broken. You're driving down the street and you bump the fender of somebody in front of you. You didn't mean to do it. It's a tort. Now, criminal laws mean the laws were deliberately broken. You're running away from somebody in your car and you're zigzagging in traffic and you're hitting cars all over the place. Yeah, that's criminal. All right, when a doctor withdraws or stops treating a patient, when they withdraw medical care from a patient, a certified letter must be sent to notify the patient. Certified means you have to go to the post office, you get the little green card, you fill it out, you put it on the back of the envelope. It means the patient or whoever the addressee is has to sign for the letter. And then that card gets mailed back to the doctor while the patient gets to keep the letter. But the card proves that the patient did receive the letter, because a lot of times they'll say, and the doctor will withdraw treatment. Like, if you're not following their directions, like taking the medicine, they're not going to treat you. They're going to go, why? I don't want to be held liable for something that you're not doing, all right? Okay, obligatory task. This is defined as an obligation people either have or they perceive themselves to have. This could be conduct, services, or functions. Now, duty is an obligation. It is your duty to make sure. Look, when you start working in this field and the office opens for 9, that doesn't mean you're going to get there for 9. You're going to have to get there about 8:30 at least, because there's a lot of equipment that has to be turned on. And some of the equipment is like a lady. It takes a little while to warm up, if you get my drift. So you can't just go in there and flip switches and start seeing patients, all right? You got to make sure the charts are all in order. There's a front sheet on the chart where the person can put in the chief complaint and whatever. So that's your obligatory task or your function. Now we get to the 4 D's of negligence. I'm going to tell you all of them and then go back. The first one is duty. Notice all 4 of these words start with the letter D. Duty, dereliction, direct cause, and damages. And this is almost the order in which they receive. Duty means the patient and the doctor have a professional relationship. That's the doctor's obligation and the patient's obligation and duty. They have a professional relationship. Dereliction is the failure of the provider, who's the doctor, to perform their duty. Now, again, with this, remember dereliction, you got to prove negligence. You can't just say, oh, well, they did this. And you have to really prove it. And it's not as easy as you think sometimes. The third D is because of the dereliction, there was a direct cause. The patient must prove that the provider was aware of the risks involved and didn't inform the patient. Let's say you have trouble with your blood clotting, so you have to take a blood thinner and aspirin every day, and you have to go to this doctor for a little major procedure in your mouth. They should look at your chart or ask you, are you taking Lovenox or aspirin or anything that's a blood thinner? If you say yes, they're obliged to tell you, and it's their duty to tell you, you have to stop taking it at least 5 days before the procedure. Now, if the doctor doesn't tell you that, all right, and they do the procedure and you bleed out, yeah, you got a direct cause. Finally, damages. Because of the direct cause of what happened, damages. It can be physical, mental, emotional, financial harm was caused by the breach of duty. Now, compensation for pain and suffering is included under general damages, all right? So that's the 4 Ds. Duty, in order. Relationship, dereliction, didn't do something right. Direct cause, it caused a problem, and then it caused damages. Contract law is an agreement that creates an obligation when the MA or DA is obtaining the patient's payment information even before an appointment. That's a good example of contract law. They're calling to make their first appointment. You have to get their insurance information so you can tell them if there's a copay, what it is, or whatever they call that. I forgot what it copay. And you have to find all that information out. Well, just by them giving you that information over the phone, even though they've never laid eyes on you, it's called a contract. It's a contract law. Documentary evidence. This includes the patient's medical record. The patient's medical records is a legal document. Watch what you write in the patient's chart. Don't use homemade abbreviations. Use only accepted medical or dental abbreviations, because if something happens to this patient and they file a suit, you know our judicial system does not move swiftly. It's long and slow, and it may take 7 or 8 years. And then you're called to court 7 or 8 years later to explain to them why you wrote this in the patient's chart. I don't even remember the patient, much less what I wrote or what that means. So make sure what you put as a foundation and it's factual, all right? But anyway, it's a legal document and it can be brought into a court of law, and you will have to explain your notes in the patient's chart. The MA or DA cannot legally perform any skills you haven't been trained to do. Now, if you have been trained to do something like CPR, you're covered under the Good Samaritan law. That does not mean that you go out there and you just start pumping and blowing and willy-nilly and not paying attention to how you're doing it. No, the Good Samaritan law says you are trained in what you're doing. Should you be doing CPR and you break a rib, you're covered. Because before the Good Samaritan law, people would see people laying on the ground and step over them and say, I'm not getting involved. I don't want to get sued. So there's where the Good Samaritan law comes in. Now, each state has its own consent laws that have to be followed. So now when you take the registry, it is a national certification. It's not just for one state like a lot of them are. So you will be nationally certified, but make sure if you move to a different state, you understand what their consent laws are and the age of consent and whatever. You, as the MA or DA, cannot explain the consent form to the patient. It must be explained by the doctor. But you are the one responsible for getting it signed. Don't let your doctor make a move on the patient without the consent form being signed before the procedure begins. Because if he starts cutting or she starts cutting and you go, oops, they can see your eyes through over the mask, all right? And eyes are the windows to the soul. You start going like this. You're going like this. Come on, you don't have to see my whole face, all right? You can't explain the consent form. The doctor has to do that because there's other things that have to be explained as well. But it's your responsibility to make sure you get it signed. Now, we're going to go ahead and stop here. I sent you a little worksheet with like 17 questions on it. Please work on that, and we're going to go over that on Wednesday also. But I'm going to go ahead and stop here before YouTube kicks me off. And it took a little while to send the pre-med, but it gets there. I'm going to send this one to you too, all right? All right, y'all have a good afternoon. See you tomorrow, baby. Bye.